Recording in
of a
progress.
writing, including electronic record in any manner, which it may be viewed by another person. So it doesn't require, at least per the statute, that it's directly written to the person that they're intending to throw.
Yes, Your Honor, that was the argument that I initially made, though the statute has been amended. The case law that I cited is still good law, and I think the court should follow that. If the court is inclined to find probable cause, given that Mr. Waters has no convictions, and the court grant pretrial services, and if they won't take him, order him.
What cause?
7,500.
They won't take 75.
$2,500.
70.
70.
Brown. Neil. So you check battery over person was 5 control possession, tampering with.
Your Honor, on the front of the it does not state the age of the person, so I'm challenging probable cause as to the first count.
And I agree, it is missing, Your Honor, requesting a reset for tomorrow.
Reset. One piece. No problem cause here. Here, Bert, Rashad. Third job.
2,500.
We'll try.
Here.
It's just the site has trespass.
Yeah, he has no priors. I would let the court grant TAP with an alternate bond.
All right. You have no question?
All right.
No objection.
And to stay away from 306 Northwest 22nd Street. Must be the code.
Tap 25.
Yep. Isono, Fernando.
We need to pass Busono. If we could call Mr. Barrera Zavidar.
Yes.
Barrera.
It's NBC.
Mr. Bissono refused, Your Honor.
You want to reset it for tomorrow?
Yes.
In Your Honor, for Mr. Busono, I don't have any probable cause argument, so I would just be requesting TAP with an alternate bond given the nonviolent nature of the charges. I'll wait on present.
You're waiving it?
Yeah.
Oh, yeah. Oh, yes, Robinson. Are we talking about Bisono?
Bisono refused. I'll waive his presence for the purpose of this hearing. And given that he's homeless and there's no violent allegations, I'm asking for TAP with an alternate bond.
For Busono, Your Honor, I would be objecting. I would just be seeking the standard bond.
Reset. Barrera, you? Your judgment bit bad.
He needs the Spanish interpreter.
Number 16 arrest.
Se
With violence.
Se le acusa de agresión física con agravantes y resistencia a la policía con violencia.
And Your Honor, this should be a third-degree felony, not an aggravated battery. Again, there's no great bodily permanent disfigurement, but if it's a battery on a law enforcement officer, it's a third-degree felony.
Su señoría, eso debería ser un delito mayor del tercer grado. No hay indicios de daños corporales graves, debería ser delito mayor del tercer grado.
State,
In the statute now, Your Honor, to our knowledge,
I don't see a weapon. I don't know what he hit him with.
El juez dice que no ve que indique qué arma, con qué fue que se le agredió.
So, Your Honor, the argument here would be that we have a law enforcement under the statute 784.045, great bodily harm, arguably by the defendant swinging his right leg and kicking the officer on the left side of his face. It caused his left eye to swell, redden, bruise.
Su señoría, dado lo que se ve aquí, que fue agresión física contra un oficial del orden público,
That makes
el
it a great
estatuto
battery.
784.045 dice aquí que le pegó él con la pierna derecha en el lado izquierdo de la cara del oficial, haciendo que se le hinche el ojo.
I figured that's what the officers consider to be great bodily harm.
Supongo que eso es lo que están considerando los oficiales con que es
Vale,
daños
vale.
corporales graves.
Third degree. All right, third degree felony. Your Honor.
5,000.
All right, so he's dropping it to 5,000 on count 1 and count 2. 25.
Entonces es fianza de $5,000 por el cargo número 1, 2,500 por el cargo número 2.
I try one.
That was straight bond, Your Honor.
Yes. Figueredo. Valdez. Been a long time.
He refused for Your Honor.
Oh. I'm sorry. All right. Reset. Tomorrow. Okay, we passed. This one too. All right. I got a Scott. I have a Pierre. And I have the Pierre, the interpreter.
You have Stephen Nelson. He refused also to sit for tomorrow.
Oh. This one? Okay. I didn't get mixed up. All right. Which one is correct?
I think we're asking to recall number 15, Mr. Scott. He's on
Correct.
4 of your
Scott.
calendar.
Scott. Good chart with possession, correct, and drug proof. What are the state?
2,500 and 500.
One of PC, 25 in one.
Your Honor, I'm asking for tap given that he's homeless.
Okay. Hold on.
No objection, Judge.
Tap to the bottom, 25, 100 count. Okay. It's the interpreter, the Creole interpreter.
Tap also.
Yes, Your Honor. The
100, Your Honor.
interpreter is present.
Yeah, 25,500. All right, let's do Mr. Pierre. Is that Mr. Pierre? Looks so.
Can we call Mr. Lowe, page number 22, page 6 of your calendar?
Low, got a battery, they need.
He's on Mr. Lowe.
You take him? I'm sorry.
Added charges.
Oh, is it?
It's an added charge. He's sentenced to February 19th. His sentence expired February 19th of 26.
What is it? Dollar bond.
You said $1 bond, Your Honor?
Yes. Now come here. Interpreters. All right, Pierre. Yes, you are charged with aggravated assault. One misdemeanor battery. You
I'm
want
so, I'm sorry, Your Honor. Assault, and what was the second one?
misdemeanor and a misdemeanor battery. Aggravated assault.
Monsieur ko eseye bat ou moun, et puis que ou cause ou gon lot ti crime.
And Your Honor, I asked for pretrial services. He has no local priors and he has a local address.
Et juge nou mande pou yo ba li program nan, paske li pa gen aucun antécédent, et li gon adresse lokal.
They won't take.
Would the court be able to order him in, given he has no local priors and a local address?
Nope. I'm gonna set the defendant bond. PC. What is it?
5,000, 1,000.
1,000?
Yep.
Count
1,000 and
1,000.
I'm sorry, 5,000 and 1,000?
Yes.
Accusation numéro non, que faut le payer caution. Donc, accusation numéro 1, $5,000. Accusation numéro 2, $1,000.
Sir, you're to stay away from Dulange.
Faut arrêter loin de l'âge
Pierre.
Pierre.
How many juveniles? I'm asking the officer, back, which is not listening.
Officer, how many juveniles? I'm sorry.
One, we couldn't do it tomorrow. Is he out of custody?
They need a Spanish interpreter.
Oh, I can speak. All right, weekend. You didn't take it?
Judge, sorry.
Oh,
They need a Spanish interpreter in the juvie side, is what you said? Okay,
Right.
I'll be right there. Thank you.
well. Counsel,
I didn't have Mr. Figueroa Valdez or Mr. Nelson addressed.
Madam Clerk, that's for you.
I was told to waive their presence and have the court set a bond so that Judge Glazer's calendar isn't long tomorrow. So just putting that request.
Okay.
Recording stopped.
All right, sir, tell me your name.
Tavius Williams.
Okay. All right, sir, I reviewed a probable cause charging affidavit that charges you with trafficking in methamphetamines, possession of cocaine with intent to sell or deliver, and possession of controlled substance, possession of cannabis, and possession of drug paraphernalia. I do find probable cause. I'll appoint the Office of the Public Defender to represent you. All right, with respect to $1,500, count 3. Bond will be stayed in the sum of $2,500. count 4 and 5, bond is stayed in the sum of 500 respectively. All right, sir, at the time of your arrest, you were out on bond in 2 cases. I'm going to revoke your bond in each case. This is 2025 CF 7601, possession of MDMA, and 2025 CF 6472, possession of cathinones with intent to sell or deliver, etc. Having found probable cause to believe that you violated the laws while you were out on bond in each of those cases. All right, condition of your release in the first case, though, sir, is obviously that you not be in possession of any controlled substances that are not legally and validly prescribed to you by a physician. All right, thank you. Your name, ma'am?
Renisha J. Wooden.
Thank you. All right, I've reviewed a probable cause charging affidavit. It charges you with trafficking in MDMA, possession of oxycodone, possession of cocaine with intent to sell or deliver, and possession of cannabis. I do find probable cause as to each. I will appoint the Office of the Public Defender to represent you in this matter. I am going to set bond in count 1 in the sum of $7,500, count 2, $2,500, count 3, $7,500, count 4, remain stayed at $500. Conditions of your release will be that you not be in possession of any controlled substances that are not legally and validly prescribed to you by a physician. All right, thank you, ma'am.
Thank you.
All right, tell me your name.
Evan York.
Sir, I reviewed a probable cause charging affidavit. It charges you with robbery. It charges you with possession of an anti-shoplifting device and petty theft. I do find probable cause. I'm going to appoint the Office of the Public Defender to represent you. As to count 1, I'm going to set bond in the sum of $8,500. Count 2 will remain at $1,000. Count 3, it will remain at $500. Conditions of which you will not return to any target in the United States. You have a violation of probation. You're being held no bond in that case, sir.
Yeah.
Yes.
The state actually, if you're looking, we actually might need to orally amend the charge.
I'm sorry, can you go ahead?
The state may need to orally amend the charge.
Are you talking about the larceny anti-shoplifting device?
No, the robbery. Here
All right.
should be a robbery with a deadly weapon.
Okay. All right, so
And
what is the statute that you want to amend it to?
so that would be.
Look at Florida statute 81213.
That would be Florida statute 812.13 subsection 2A.
All right, that's granted.
And in that regard, then the state would be moving for a pretrial detention motion as well.
All right, right, so it'd be robbery with a deadly weapon. Is that elevated to what?
That would be a first degree felony.
F1? Okay. All right, defense, any argument as to the amended charge?
We would be asking for a written information instead of an oral information.
So you're objecting to the oral amendment. Am I hearing that right?
Yes, Your Honor.
Okay. Well, given the facts, I am going to grant the oral amendment. And I am going to hold him without bond on that count, that first count, robbery. Okay.
May we also get the division number to that one as well?
I'm sorry?
The division number and
division
the
it's
date
assigned
on
to?
that one.
The division that it's currently scheduled in for the trial judge is Division 10, which is Falcone. The PTD is going to Division 18 on October 16th at 9 a.m., courtroom 7B.
Thank you so much.
You're welcome.
All right, thank you, sir.
Thank you.
You Kenneth King?
Yes, ma'am.
Mr. King, there was an outstanding warrant for your arrest. The issuing magistrate set bond at $200. That's what you were detained on, that open container. So I'll appoint the Office of the Public Defender to represent you, and bond will remain at $200, okay?
Yes, ma'am.
All right, thank you, sir.
Sir.
Sir, what is your name?
Keegan Karut.
Inmate number 250-31840. That's what I have next is Peter Awad. Did he bond?
You said 2503.
Yeah, 2503-1840.
Yes, he bonded.
Thank you. All right, sir, you are, again, your name?
Keegan Karut.
All right. All right, sir, reviewed a probable cause charging affidavit. It charges you with attaching tag not assigned and no motor vehicle registration. I do find probable cause. I'll appoint the Office of the Public Defender to represent you in the case. Bond will be stayed in the sum of $500 per count. Conditions of your release will be that you not operate any motor vehicle without a valid registration or an assigned tag. Thank you, sir. Sir, tell me your name.
Dawn Lacey.
Mr. Lacey, I'm reviewing a probable cause charging affidavit that charges you with operating a motor vehicle at a time when your license was suspended. I do find probable cause. I will appoint the Office of the Public Defender to represent you. Can you hear me fine?
Yes, ma'am.
Okay. All right, with respect to bond in that case, bond will be stayed at $1,000. You were out on bond at the time of this offense for a DUI, 2 prior convictions in case number 2025 CF 509. Your bond will be revoked in that case for the court finding probable cause that you were out on release at a time when you violated the laws. So that will be it on that case, sir. Thank you. Sir, your name?
Eric Scott.
Sir, I reviewed a probable cause charging affidavit that charges you with DUI, with a prior DUI conviction and refusal to blow. I find probable cause for the DUI. State on the blow, it indicates that he successfully blew twice. And the third opportunity, it just says he did not successfully provide one within the required time to complete the breath sample. As a result, he was giving a refusal. I'm having a hard time finding PC on that.
I did equally read that. My understanding is that normally they give 3 samples, so my belief off just the 4 corners is that only 1 sample was given, although I will agree with Your Honor that I did equally see
Okay.
issue.
All right. So I'm going to ROR him on the second count. I'm not finding that there's any PC. Point the Office of the Public Defender. As to the first count, the DUI, bond will remain at 1,000.
Your Honor, he does qualify for PTR.
Oh, okay. Thank you for that. All right, sir, I'm going to release you to pretrial release with the condition that you not be in possession of any alcohols. Alcohol, you not operate a motor vehicle without a valid driver's license, and you not visit any places where their primary source of revenue is from the sale of alcoholic beverages. In other words, no alcohol. Do you understand?
Yes, sir.
All right, thank you. Sir, tell me your name.
Shivendra Sharma.
Okay. So I reviewed a probable cause charging affidavit. It charges you with DUI and a refusal to provide a breath sample. I do find probable cause. I'll appoint the Office of the Public Defender to represent you in this case. Bond on the DUI will remain at $1,000, the refusal at $1,000. Conditions of your release will be that you not operate a motor vehicle without a valid legal license and that you not be in possession of any alcohol. You may not visit places where their primary source of revenue is the sale of alcohol, such as a bar. Do you understand that?
Yes, ma'am.
All right, thank you, sir. Sir, tell me your name.
Michael Burnett.
Okay. Mr. Burnett, I've reviewed a probable cause charging affidavit. It charges you with possession of drug paraphernalia. I do find probable cause. I'll appoint the Office of the Public Defender to represent you in this case. With respect to bond, I'm going to reduce bond to $100 with a special condition, sir, that you not return to the scene of the offense and you not be in possession of any narcotics that are not legally and validly prescribed to you by a physician. Thank you, sir. Yes, that was Burnett, reduced to 100, yeah. Ma'am, tell me your name.
Demetrius Burton.
All right, ma'am, I've reviewed a probable cause charging affidavit. It charges you with trespass, resisting an officer without violence, and disorderly intoxication. I do find probable cause. I'll appoint the Office of the Public Defender to represent you. As to bond, on count 1, that'll be reduced to 100. As to count 2, that will be reduced to 100. As to count 3, that will remain at $150. Special conditions will be that you not be in possession of or consume any alcoholic beverages, you not return to the scene of the offense.
Yes, ma'am.
Now, at the time of this offense, you were out on bond in case number 2025 MM100282. Based on a lack of a substantial prior history and based on these facts, I'm not going to take any action with respect to revocation of your conditions of release in that case. All right, thank you, ma'am.
Okay.
Are you Ms. Holloway?
Yes.
All right, ma'am, I've reviewed a probable cause charging affidavit that charges you with trespass. I do find probable cause. I will point the
We had fixed it. I needed to go to a different airport. They said that one I couldn't go to. So they gave me information and they told me what airport I can go to. I said, okay, thank you. I'll go to that one. That was it.
that I told you previously that you couldn't go to the airport, right?
No, you said I could go, but I have to buy a ticket.
Oh, right, buy a ticket.
They said I
You
can't
couldn't
do
go
that
unless you bought a
either.
ticket. Okay, all right.
They said I couldn't do that either. They said I have to go to the one on Sanford and all that. I said, oh, okay.
Okay, all right. All right, ma'am, again, I find probable cause. Bond will be stated 1,000. And with respect to the case that you're out on bond on, 2025 MM 408210, I'm going to revoke your release status, hold you without bond in that particular case. I think you're RR'd on that case by me. All right, thank you, ma'am.
Your Honor, Hunt Vaughn has refused.
Okay. Do you want to waive appearance?
No, could we reset this one for tomorrow, please, Your Honor?
Okay. It'll be reset for tomorrow then?
For, in case there's a plea offer tomorrow on this.
Your name, sir?
I want generate.
Okay, thank you. Who is NBA Youngboy?
He is a prominent artist.
Okay. It just tells me I'm just old. Okay. All right, sir, I've reviewed a probable cause charging affidavit. It does charge you with city ordinance violation of fake sales and resisting an officer without violence. I do find probable cause. I'll appoint the Office of the Public Defender to represent you. With respect to your release, sir, you have bonds set at $500 in each case. I'll reduce them to $100 in each count, I should say, not case, each count, for a total of $200. Condition of your release will be that you not return to the scene of the offense, sir. Thank you.
Your Honor, Jones Bernadette is mental health.
We'll waive, Your Honor.
Okay. So waiver of appearance, PD's office is appointed. She's charged with trespass. The court has reviewed the probable cause charging affidavit. I do find probable cause. Bond will remain stated in sum of $1,000 with a condition of no return. Sir, tell me your name.
Matt Bean.
All right, so I reviewed a probable cause charging affidavit that charged you with resisting an officer without violence. I do find probable cause. I'll appoint the Office of the Public Defender to represent you in the case. Bond is reduced to $1,500 with a condition that you not return to the scene of the offense. Thank you, sir.
Your Honor, Lopez Jose is behavior today.
Lopez was what?
He doesn't speak English?
Behavior.
Oh, behavior. You wish to waive his appearance?
Yes, Your Honor.
All right, so the court will find probable cause. As the co-defendant, I will set bond in each case at $100 with a condition that he not return to the scene of the offense.
Your Honor, Mata Stephen is refused.
You waive his appearance?
What is an AFIS hold? What does that mean?
Fingerprint.
That's AFIS, that's fingerprints.
Maybe if we could reset this one for tomorrow, to see if there's a
Oh, sorry, couldn't hear you. Reset it to see what?
Yes, could we reset this one for tomorrow to see?
See if he has a plea offer? Okay. Sir, tell me your name.
Christopher Reyes.
All right, sir, I've reviewed a probable cause charging affidavit that charges you with a city ordinance violation of fake sales and also resisting an officer without violence. I do find probable cause. I'll appoint the Office of the Public Defender to represent you. I will reduce bond to $100 per count with the condition that you not return to the scene of the offense. Okay?
Yes.
All right, thank you. Sir, tell me your name.
Dylan Tunstall.
Okay. All right, sir, I've reviewed a probable cause charging affidavit. It charges you with possession of cannabis. I do find probable cause. I'll appoint the Office of the Public Defender to represent you. Bond will be stayed in the sum of $1,000 in that case. You also have a violation of probation where you have a zero bond. Bond will remain in that case at zero. All right, thank you, sir. What is your name?
Vincent Williams.
I'm sorry, it was Vincent Williams?
Williams.
Sir, I've reviewed a probable cause charging affidavit. It charges you with possession of drug paraphernalia. I do find probable cause. Going to appoint the Office of the Public Defender to represent you in the case. With respect to bond in the matter, it will be reduced to the sum of $250. Special conditions that you not be in possession of any illicit substances that are not legally and validly prescribed to you by a physician. Thank you, sir. All right, so now we're at the misdemeanor pleables. Or are we?
I believe that was the end of the misdemeanor pleables, Your Honor.
That was the end of them, okay. Yeah, okay, thank you. Your name, sir?
Lawton McKenzie, ma'am.
Okay, thank you. Mr. McKenzie, you have been detained for a warrant out of New Orleans. Looks like the issuing magistrate set bond at zero. We'll notify the authorities that we have you, and they will come to do they will start the extradition process, okay?
You'll see someone between now and Thursday.
Now and Thursday. Thank you.
Could we have the PD appointed for jail purposes, Your Honor?
Do they usually appoint the PD for those out of county? Yeah, I've never done that. I'm going to deny that request. I think it's just a not necessary expenditure of resources. Okay. All right. Thank you, sir. Your name, sir?
Warren Muir.
All right, Mr. Muir, you have a out-of-state warrant. This is from Hamilton County Sheriff's Office. What state is that? Where does it say it?
Tennessee.
Okay, thank you. All right, from Tennessee, sir, the issuing magistrate does set bond at zero. Bond will remain at zero, and the extradition process will commence. Did you hear what Madam Clerk indicated about someone by Thursday will come see you?
By Thursday, do that mean I have to, like, how many days do they got to come get me and stuff?
I don't know, sir, but someone will come see you by Thursday, okay?
Okay, thank you.
All right, thank you. So your name?
Early Oliver.
I'm sorry, your name?
Early Oliver.
Okay. Mr. Oliver, you likewise have an out-of-state warrant from Hamilton County, Tennessee. The issuing magistrate set bond at $2,500. Bond will remain. It looks like it's a failure to appear on a driving while license suspended. And this is just a duplicate, right? Yeah. All right, sir.
Excuse me.
Thank you.
Excuse me, Your Honor. You said Tennessee? No, mine is from Hamilton, Columbus, Lake City.
It's in Florida. It's Hamilton County.
Hamilton County, yeah.
That was my bad. Hamilton County, Florida.
Yeah, Hamilton County, Florida. Yes, ma'am.
All right.
Tennessee, sir? Oh, no, I don't want to go to Tennessee.
All right, Brandon Powell.
Yes, ma'am.
Sir, you have an outstanding warrant that you were detained on from Lake County. Looks like the issuing magistrate set bond in the sum of $10,000. All right. Lake County will be advised that we have you so that they can transfer you, okay?
Okay, Miss. Well, should I just wait till I get transferred to like try to
I
like?
don't think you have a choice to wait. I mean, you're being held here on, did you have a bond?
Yes.
Oh, I'm sorry, you can bond out if you want.
Yeah, but
You
is
can bond
there,
out $10,000.
yeah, is there any way that I could get it like lowered?
Sir, I have a policy that I do not disturb a out of jurisdiction, out of county, out of state magistrate's
Okay.
bond. They set it for a reason, so I don't mess with it.
So when I go back to Lake County, I could talk to them about it.
You can talk to them about lowering it, yeah.
Okay.
Sir, your name?
Jonathan Wells.
All right. All right, so you have a warrant out of Virginia. No bond. All right, the extradition process will commence, and we will, hopefully someone will be out to talk to you by Thursday, okay?
Do I get a lawyer for this?
No, sir, not from the state of Florida, you don't. This is a Virginia charge, not a state of Florida charge.
Well, I went through this process up in Santa Rosa County, not even 3 months ago, and they refused to come get me then, but the state had offered me a lawyer then to fight extradition.
You won't be appointed a lawyer here, sir. Okay, thank you. POPs? Okay. Yeah.
Your Honor, Hastings Tiffany is bonded.
Hastings is what now?
Bonded.
Oh, bonded? All right, thank you. So your name?
Kenson Morris.
All right.
And can I ask a question?
Yes, sir.
I was charged with the wrong thing, so I wasn't supposed to be here because I didn't have no gun or anything like that. Somebody shot at me 5 times, and then they charged me with the wrong thing because I didn't do anything.
Well, sir, I'm going to appoint the Office of the Public Defender to represent you. Everything here is being recorded.
Yes, ma'am.
Okay?
Yes, ma'am.
So anything that you say could be used against you. That's called your Fifth Amendment right loosely.
Right.
So don't tell me anything about anything until after we see what's going on here, okay? So there's a probable cause charging affidavit, it looks like, for aggravated assault with a firearm. And there's also a violation of probation. Give me a moment.
Okay, thank you. Sorry. 'Cause at the Wendy's. I was coming from work. I didn't do anything to anybody. When they check the cameras, they're gonna notice that. I didn't do anything to anybody. It's here for no reason. I tried telling them that, but they keep saying I had my reason. I don't know why. here for? I didn't do anything. They haven't shown me who shot at me, anything. I haven't done anything. I didn't check the cameras. I just went to argument. I didn't shoot at anybody. I haven't done so. I'm raising the charge of aggravated battery firearm. I didn't do anything to anybody.
All right, so I reviewed the probable cause charging affidavit and it basically says some of the things that you just stated, but I do find probable cause for the aggravated assault with a firearm.
Yep, I didn't have.
At the time you were on probation, so I do find a violation.
I don't have a firearm.
Based on probable cause.
I didn't have.
You'll be held no bond on the violation of probation. As to the aggravated assault with a firearm, and if I haven't said it so already, I do appoint the Office of the Public Defender to represent you.
I didn't have a firearm, Honor.
As to the aggravated assault with a firearm, I am going to set bond in that matter, but in the sum of $15,000. Conditions of your release in that case will be that you will not be in possession of any firearms, any ammunition. You will not return to the Wendy's. So your attorneys who are appointed to you can sort all this out for you, okay? My job here is to find probable cause, not guilt or innocence, okay? Probable cause. It's a very low standard. Thank you, sir.
Let's go. Ask for a bond hearing if you want.
Let's go.
You need to ask that.
Your Honor, Thomas Robert has refused.
Do you want to waive his appearance?
Yes, Your Honor.
All right. So Mr. Roberts has been picked up on possession of oxycodone, MDMA, and cannabis. Court finds probable cause. Appoint the Office of the Public Defender. Bond will be stayed in all counts and all amounts. I will find a violation of his probation and hold him without bond on the VOP. Okay, it looks like we only have Barnes and that's it, right?
Mr. Barnes?
All right. Sir, tell me your name.
Joshua Barnes.
Right. Sir, there is a probable cause charging affidavit charging you with a city ordinance violation of camping.
Yeah.
Also, basically theft of a shopping cart. State, I'm not finding any PC on the theft of a shopping cart, unless you can help me out here. But is this a situation where it could be a plea?
Yes, Your Honor, we can offer on, we can offer
Okay.
the CCS on this.
Okay. Sir, the offer, if you want to enter a plea to it, is, and that would be just on the camping. I think.
Yes, Your Honor, I can,
You can null process the second, okay. That would be credit for time served. Obviously, you would have a camping city ordinance violation on your record, but it's up to you as to whether or not you want to accept that offer, if you want to reject it. Your court costs will be reduced to a civil judgment. You want to take a moment and discuss that with the attorney to your left and see if that's what you want to do, sir?
While they're conferring, Your Honor, I think the only other thing for city cases is a $10 filing fee for city ordinances.
Is there?
I believe so.
Okay, so I can't waive the $10 filing fee, I'm being told. Okay, reduce it to a civil judgment.
So it's just for the camping only.
Mr. Barnes, are we gonna go ahead and take this plea?
Mr. Barnes, do you want to enter a plea?
Yes.
Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you're going to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, again, tell me your name.
Joshua Barnes.
Mr. Barnes, what's being offered to you, and you certainly do not have to accept it, but is the entry of a plea of guilty to camping, and you would be adjudicated guilty of that, given credit for time served. There's a $10 filing fee that would be reduced to a civil judgment against you, which would mean if you ever own property in the next 20 years, then it might be something that you have to satisfy that $10 before you can sell that property. Do you understand that?
Yes.
Is that what you want to do, sir?
Yes.
Is anyone pressuring you, threatening you, or forcing you to do so?
No.
All right, you have a plea form. If you've read it and discussed it with your attorney, you can sign it. Yeah, exactly, yeah. All right, sir, is that your signature on that plea form?
Yes.
Anyone pressure you, threaten you, force you, make you sign that?
No.
All right, sir, I'll accept your plea, adjudicate you guilty of the city ordinance violation, give you credit for the time that you've served. Madam Clerk?
It is going to be a total of 1 day served, and your court cost is $233.
Those will be reduced to a civil judgment against you, sir. All right. You have 30 days to appeal the court's disposition. If you wish to do so, it's got to be filed in writing. And if you could not afford an attorney, one will be appointed to represent you. State your no processing the
Yes,
second
Your Honor,
time.
in exchange